Cable television, are you ready?
Yes, sir, we are ready.
Great. We're going to start in just a second.
Okay.
When Blaine tells me we can start. I'm going to start now. I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Thursday, November 3rd, 2022. The time is 11:27 in the morning, and this hearing is being conducted virtually. I believe it's being broadcast live via the chairman's website, which is www.chairmanmendelson.com/live. I believe it's being broadcast live on Council Channel 13 and the Office of Cable Television website, which is entertainment.dc.gov, and the Council's website, which is www.dccouncil.us. The subject of this hearing is Bill 24-658, the Consumer Protection Procedures Amendment Act of 2022. This legislation was introduced earlier this year in February by Council Member Brooke Pinto, joined by Council Members Louis George, Bonds, and Allen. The stated purpose of this bill is to prohibit retaliation against consumers who report consumer protection violations pursuant to the Consumer Protection Procedures Act, to allow the Office of the Attorney General to bring consumer protection cases against political action committees and charitable groups that have violated the Consumer Protection Procedures Act, to establish a minimum penalty for Consumer Protection Procedures Act violations, to enhance the Attorney General's ability to gather information during investigations of consumer protection violations, and to authorize the mayor and the Attorney General to issue rules necessary to implement the law. I will note, in case one gets the impression otherwise, that there is already in law the Consumer Protection Procedures Act. And I look at this legislation as seeking to strengthen the protections for consumers. That is a role the government can perform, and I think it's an important role, since sometimes individuals can be taken advantage of or misled, and it feels like they're just a small fry in a big fish tank. So this kind of legislation is important. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Thursday, November 17th, 2022. To be clear what this means, we're required to file a record after our hearings. And so we have a cutoff, and that cutoff is 2 weeks. That doesn't mean we won't consider comments received afterwards, but they may not be included in the record. With that, let me turn to my colleague, Councilmember Brooke Pinto, in case she has an opening statement, and then we'll turn to the witnesses. Councilmember Pinto.
Good morning. Thank you so much, Chairman Mendelson, for your comments and for holding this hearing on this bill today. As you noted, I introduced the Consumer Protection Procedures Amendment Act of 2022 last winter to ensure that the Office of the Attorney General has the authority they need to protect consumers in the district most effectively. The Consumer Protection Procedures Act, also referred to as the CPPA, is one of the most effective legal tools that the Office of Attorney General and the now Department of Licensing and Consumer Protection have to protect consumers. However, since it was passed in 1976 and has never been substantially updated, it hasn't kept up with changing dynamics that we've seen in the district. This bill aims to clarify language in the CPPA and address weak points that have made OAG's investigative and litigation work more challenging, to protect those who come forward with complaints from retaliation, and to expand OAG's authority to protect consumers from political action committees and charitable organizations that violate the CPPA. The work that the Office of the Attorney General and the Department of Licensing and Consumer Protection do to protect consumers are both vitally important. And the intention of this bill is not to take away authority from the Department of Licensing and Consumer Protection or in any way weaken their ability to educate and protect consumers. I'm very open-minded to discussing ways in which this bill can be strengthened to ensure that both agencies have the tools that they need to best serve district residents. While there may be some room to further expand this bill, I am confident that the provisions currently included are sensible and needed reforms that are immediately needed in order to best protect consumers. So I'm looking forward to hearing from our government witnesses today and moving forward thereafter. Thank you.
Thank you, Councilmember Pinto. We have only two witnesses, and so I'm going to invite them both in. Adam Teitelbaum, who is Director of the Office of Consumer Protection within the Office of the Attorney General, and Shirley Kwan Hui, who is Interim Director of the Department of Licensing and Consumer Protection. The Department of Licensing and Consumer Protection used to be part of DCRA. DCRA disappeared on October 1st, and two new agencies, one of which is Department of Licensing and Consumer Protection, were birthed. So she's representing them. We'll hear from each of you, and then we'll do some questions. Mr. Teitelbaum, you want to go first?
I'd be happy to, Chairman. Good morning, Chairman Mendelson, council members, staff, residents of the district. My name is Adam Teitelbaum. I'm the Director of the Office of Consumer Protection at the Office of the Attorney General for the District of Columbia, known as OAG. I'm here to express OAG's strong support for Bill 24-658. I thank you, Councilmember Pinto, for introducing this bill, which we believe will provide important updates to the district's consumer protection laws. OAG enforces the Consumer Protection Procedures Act, again known as the CPPA, to protect district consumers from a wide array of misconduct by businesses, including deceptive practices, employment abuses, violations of tenants' rights, civil rights, and conduct that harms the environment. Through its enforcement of the CPPA, OAG has gotten important results for consumers. Just in the past 8 years, we've delivered more than $35 million in restitution that goes back into district consumers' pockets. We've collected more than $88 million in payments and penalties that goes toward broader efforts to support consumers. And we've obtained nearly $80 million to support the victims of the opioid crisis. That said, the CPPA should be updated to ensure that it continues to effectively deter violations of the law. And it should be clarified to avoid the need to litigate the meaning of several of its provisions. This bill would provide those important updates and clarifications. First, it would clarify that businesses that supply goods and services are included in the definition of merchant and thus are encompassed by the CPPA, regardless of whether there's a formal exchange of money or value. What this does, it ensures that those companies that provide purportedly free services, social media companies, other companies that trade in consumer data, that ensures that those entities too cannot engage in deceptive business practices and are encompassed by the CPPA. This is an important clarification because our office has expended significant resources litigating this issue. For example, we brought a lawsuit against Facebook relating to their Cambridge Analytica data breach. And in that case, Facebook argued that it should not be subject to the CPPA at all and could not be held accountable for its conduct because it provided a free service and therefore was not a merchant. Fortunately, we won that argument, but at significant cost in terms of having to litigate this issue through briefing and at a significant delay to our case. And so this clarification would avoid a repeat of those scenarios in the future and would ensure that anyone involved in the marketplace for goods and services, even if they don't directly charge consumers, are subject to the CPPA. Next, the bill would expressly prohibit unlawful transactions, which would bring district law into line with the consumer protection statutes in other states. Currently, the current version of the CPPA expressly prohibits only unfair or deceptive trade practices. Although OAG has successfully argued that the violation of other laws in the course of consumer transactions also violate the CPPA. Those battles as well have been hard fought, and this amendment rather, would clarify and make the law crystal clear. If you violate any law while doing business in the district with the district consumer, you are subject to liability under the CPPA. I should note this provision would mirror a very similar provision contained in California's consumer protection statute, which has been applied for decades successfully and is viewed as a model and one of the most effective consumer protection statutes across the country. The bill would also prohibit harmful practices that we've seen in the course of our litigation and investigations. For example, because there have been several reports of charitable groups or political action committees making misrepresentations in connection with their solicitations of donors and of contributions, this bill would add a new section to the Charitable Solicitations Act to clearly prohibit misrepresentations in soliciting donations. In addition, we've seen businesses threaten defamation lawsuits against consumers for filing consumer protection complaints with our office. This is a real problem. This threat of retaliation has a chilling effect on victims or witnesses who would otherwise come forward, and is critical in identifying issues for us and in supporting our ability to effectively litigate those cases. This bill would therefore update the CPPA to prohibit this sort of retaliatory conduct, much like other whistleblower protections and other statutes. I should note we would also strongly support adding language to the bill to make it clear that this prohibition on retaliatory conduct applies equally with respect to consumer complaints made to our sister agency, the new Department of Licensing and Consumer Protection, DLCP. This is critical in part, and I should note that DLCP, OAG, we have a shared mission of protecting district consumers from all manner of harmful business practices. We've worked really well with DLCP's predecessor agency in this space, DCRA. We have a strong history of coordinating, sharing information about concerning trends, referring matters to one another within our respective areas of expertise. We look forward, and I personally look forward to continuing that close relationship with the new agency and finding additional creative ways to collaborate with DLCP to ensure we're continuing to serve the needs of district consumers. In addition, the bill would clarify OAG's enforcement and investigative authority, given that OAG is the agency tasked with bringing litigation in court under the CPPA. And it would expressly allow our office to use commonly accepted investigative and enforcement tools to protect consumers, vulnerable adults, and the elderly. First, to help ensure that the CPPA effectively deters misconduct, the bill would establish minimum penalties for companies found to have violated the CPPA in OAG actions. Because under the current law, there are no mandatory penalties, courts do not always order them. We had one recent case where a residential property management company was in fact found liable for engaging in deceptive advertising and other harmful practices, but the court did not order the company to pay any penalties. Instead, the company was required to pay back its ill-gotten gains, essentially the money that it had defrauded consumers out of, leaving the company no worse off than before it engaged in the deceptive practices. If companies only need to return money to consumers that they deceive, and only when they get caught with no added penalty, companies will not be incentivized to follow the law. This change would align the district's law with the law of other states, as well as with district enforcement laws in other contexts, including the False Claims Act, which sets a minimum penalty of $5,500, significantly higher than what the current bill under the CPPA requests. $5,500 for each false or fraudulent claim made to the district. The bill would also allow a court to order remedies in cases brought by our office that are designed to prevent particular kinds of harm to consumers, such as enjoining a company from engaging in certain past practices, freezing a company's assets, placing it into receivership, or in extreme circumstances, dissolving the company altogether. This would align the CPPA with similar remedies that are permitted in the nonprofit context under the Nonprofit Corporations Act, as well as in the landlord-tenant context under the Tenant Receivership Act. The bill would, in addition, allow the court to require wrongdoers to pay reasonable costs and fees that OAG incurs in the course of an investigation. This is another provision that was drawn specifically from our own experience. Several companies have challenged our authority to issue investigative subpoenas, even though the statute allows us to do so. But they do so because they know that that challenge alone will delay investigations, often by months, because in order to enforce subpoenas, we're required to file an action in court and get a court ruling forcing them to comply. And so having this cost provision and fees provision would ensure that companies are deterred from engaging in these delay tactics and know that they will have to pay costs and fees if they lose these frivolous arguments. The bill would also allow OAG to more effectively work with other law enforcement agencies to prevent misconduct by authorizing us to share confidential documents that we gain in the course of a case with other appropriate law enforcement agencies. Companies have often asked courts to order us not to share documents that they consider confidential with other law enforcement agencies, such as attorneys general in other states that may have jurisdiction over certain misconduct. The inclusion of this common information sharing practice in the CPPA would foreclose those future attempts to prevent efficient and effective cooperation with other law enforcement agencies. The bill also authorizes OAG to require subjects of consumer protection and financial exploitation investigations to answer written questions under oath during an investigation. Currently, OAG can subpoena documents in those investigations, but the current state of the law does not allow us to require companies to submit written answers to questions under oath, a common tool in investigations. Allowing this authority would mean we could more quickly conclude investigations by getting quick answers to questions that might resolve our concerns, or where those answers would lead us to decide that further action is necessary, we could more quickly progress toward that further action. This is authority that OAG already has under the False Claims Act, as well as our antitrust laws, and think it's appropriate to extend it to the consumer protection and elder abuse context. Finally, OAG suggests adding 2 provisions to the bill to further clarify the CPPA. First, OAG suggests adding a provision clarifying that the burden of proof for OAG actions under the CPPA is preponderance of the evidence, which is not only the default standard for civil cases, the standard used in other states under their consumer protection statutes, it's also the standard that applies in an array of other enforcement contexts that OAG brings. Second, OAG supports an amendment that has been proposed by other consumer advocates, in particular the legal aid community, that would clarify that those who act on behalf of merchants can equally be held accountable for violating the CPPA, even if they don't have a direct contractual relationship with a consumer. In short, this bill would help solve recurring problems in CPPA enforcement. It would modernize the district's consumer law by adding the tools and authority commonly available to attorneys general in other states. As was noted earlier, the CPPA is one of the most important tools available to protect district residents from bad business practices. But these clarifications and updates are needed to support OAG's efforts to protect the public, as well as DLCP's efforts to protect the public. District residents deserve fair and effective consumer protection laws, and we stand ready to build upon our history of protecting the public from those who would deceive them. I thank you all for hearing my testimony, and I would welcome any questions you have.
Thank you, Mr. Titlebaum. I will probably have some questions for you, but let's hear from Shirley Kwan. Am I pronouncing it correctly?
Yes, Shirley Kwan Hui.
Wait.
Thank you. Good morning.
Good
Chair-
morning.
Yeah. Good morning, Chairman Mendelson, Council Member Pinto, Council members and staff. I am Shirley Kwan Hui, the Interim Director of the Department of Licensing and Consumer Protection, DLCP. And I am here today to testify on Bill 24-658, the Consumer Protection Procedurals Amendment Act of 2022. The Council adopted the Consumer Protection Procedurals Act, CPPA, in 1976 to protect consumers from deceptive and unfair business practices by educating the public and businesses about the district's consumer protection laws, to assure that a just mechanism exists to remedy improper trade practices and to deter the use of such practices, and to promote fair business practices through effective enforcement. We can certainly all agree that the CPPA plays a critical role in protecting consumers from an array of deceptive and unfair business practices. The CPPA has not been updated in its entirety since its adoption. Understandably, how we do business, engage with merchants, and the overall consumer market have changed drastically since that time. Thus, updating the CPPA to align with current business practices is necessary to protect consumers. We commend the Council for embarking on this endeavor. While the Executive and DLCP support the underlying intent of the legislation, we cannot support the bill in its current form. Neither the Executive nor DLCP, the district's principal consumer protection agency, were consulted when the bill was drafted or prior to its introduction. In reviewing the bill, we have identified several significant concerns, which prevent us from being able to support the bill before us today. First, the bill replaces DLCP as the principal consumer protection agency, with no mention of which agency or office is now the principal agency. Second, it expands the Office of Attorney General's enforcement tools in its realm without providing comparable or similar enhancements to DLCP. Third, the bill grants both DLCP and OAG separate rulemaking authority, which could result in inconsistencies in the law, thereby confusing the public and businesses. And finally, the bill could be more reflective of the interplay between federal consumer protection laws and how the courts have interpreted those laws. I will expand on these concerns later in my testimony, but I want to reiterate that the Executive supports updating the CPPA, as it is essential to protecting consumers and businesses. With additional time to work with OAG and stakeholders, we will be able to present a bill that comprehensively updates the CPPA as opposed to taking this piecemeal approach. For these reasons, we do not support Bill 24-658. Before I dive into our concerns with the bill and how it can be improved, I want to take this opportunity to explain the role that DLCP currently plays regarding consumer protection. DLCP's Consumer Protection Unit, CPU, actively investigates violations of the CPPA that are referred to it through consumer complaints from the public. We receive complaints in person, by telephone, email, mail, online, social media, walk-ins, and through referrals from other government agencies or entities. Upon receipt of a complaint, the CPU begins its investigation by verifying that the business is licensed in the district. If the business is not licensed or no longer has an active license in the district, our enforcement team takes swift actions to issue a notice of infraction, NOI, against the owner and works with the owner to bring them into compliance with district laws. The DLCP alone is the agency authorized to issue NOIs. After determining whether the business is licensed in the district, a CPU investigator will interview the complainant, review any paperwork that has been received, ask for additional supporting documents, and reach out to the business or sellers for a response. Next, the CPU investigator will attempt to mediate the dispute with the consumer and secure an agreement with the respondent that makes the consumer whole. If the respondent does not wish to participate in mediation, or if the mediation otherwise fails, the CPU will issue a civil infractions if it is determined that the respondent has violated the CPPA. Severe and notable violators are referred to OAG for potential civil prosecution. I cannot stress enough, there is an established process for how the CPPA is enforced at DLCP. However, DLCP was only created as a new standalone agency a month ago, and it presents an opportunity to improve upon the tools granted to us in ways that this bill does not contemplate. While the current law prescribes how DLCP shall handle consumer protection complaints, there is more that can be done. Since becoming a standalone agency focused solely on licensing and consumer protection, we find this to be a great opportunity to enhance DLCP's enforcement tools to better protect consumers. Again, while we do agree that the CPPA needs to be updated and enhanced, we feel it should be done holistically and should take into consideration the roles that DLCP and OAG both play in enforcing the CPPA. With that understanding, I would like to turn now to the specific elements of the legislation that we disagree with. First, the bill would repeal DC Official Code 28-3902A, which designates DLCP as the district's principal consumer protection agency. It is unclear to the executive what purpose is served by repealing this subsection. We should not repeal this provision when DLCP is still in its infancy and when the agency has not yet had an opportunity to fulfill the council's goal of establishing smaller agencies to provide more focus per the Department of Buildings Establishment Act of 2021. It should be noted that DLCP, operating as its predecessor agency, the Department of Consumer and Regulatory Affairs, DCRA, has served as the principal consumer protection agency for the district since 1983, when DCRA was established. OAG has done and continues to do great works in bringing litigation cases in the consumer protection arena, and the district residents are better off for it. However, DLCP's mandate as the principal consumer protection agency is broader and encompasses not just enforcement actions, but also consumer education and information. We know that even though our collective outreach is broad and growing, not every consumer who is wronged will find their way to a district agency for help. We can best protect consumers by ensuring that those doing business in the district are properly qualified, informed, and credentialed. In other words, licensed. DLCP is the principal agency for business licensing in the district and has roles in both licensing and enforcement to protect consumers, and in the executive's view, should remain the principal consumer protection agency. Additionally, DLCP plays an important role in consumer protection as we accept all complaints received and conduct investigations on every complaint within our jurisdiction. Conversely, OAG does not prosecute every complaint it receives from DLCP or from the public. As previously stated, OAG has discretion as to whether they will prosecute a complaint. DLCP, however, is statutorily required to investigate every case it receives. And more broadly, it should be taken into consideration that DLCP is a new agency, having been established on October 1st of this year. DLCP's core mission is licensing, and consumer protection. It would be contradictory to the mission of the agency if we were no longer designated as the principal agency for consumer protection. Ordinary citizens should know with certainty which agency is the principal agency when it comes to consumer protection matters. I would like to note that one of DLCP's primary goals for this fiscal year is to thoroughly review and assess the CPPA and identify changes it would like to see made so that we can better protect consumers from unfair business practices and help businesses avoid violating the district's consumer protection laws. DLCP would establish a working group consisting other district agency and stakeholders to assist in reviewing the CPPA. Next, the bill provides OAG with additional tools for handling consumer protection cases without giving DLCP a comparable set of tools. For example, this bill makes it a violation under the CPPA to retaliate against any person for filing a consumer complaint with the Attorney General for the District of Columbia or any other law enforcement agencies, but leaves out retaliation in the context of complaints filed with DLCP. DLCP should be included here because we want to prevent retaliation against people who file complaints with us as well. This important context for DLCP would not have been missed if DLCP was included during the drafting process of this bill, and is precisely why a working group would be helpful to ensure that the implementing agencies and all stakeholders are involved. Finally, the bill would amend DC Official Code 28-3913 to give rulemaking authority to both DLCP and OAG to carry out the purposes of this chapter. Having dual rulemaking authority raises inevitable questions about who will take the lead in drafting rules and what would happen if there are competing rules that conflict with one another. Perhaps most importantly, rules that hold respondents to different processes could raise due process concerns and endanger the legal foundation of cases brought by both OAG and DLCP. We believe that the authority to promulgate rules should rest solely with DLCP, though the department would work closely with OAG to ensure the rules address their specific needs. Although we would prefer to have more time assess ways that the CPPA could be improved upon, I would like to highlight a few ideas that would improve the way the CPPA currently works for our agency. First, I would like to discuss the concepts of cease and desist orders and summary suspensions. Currently, under DC Official Code 28-3903A3, DLCP has the power to issue cease and desist orders with respect to trade practices determined to be in violation of district law by the department. However, if a business fails to cease and desist, DLCP is required to refer the matter to OAG, within its discretion, may restrain the prohibited act pursuant to DC Official Code 28-3909 in the Superior Court of the District of Columbia by obtaining a temporary or permanent injunction. Arguably, this places the OAG in an executive operation role without a prescribed timeframe by which OAG is required to take action. Therefore, OAG has the discretion whether it will decide to move forward with injunctive relief after a DLCP referral. This process undermines DLCP's authority against businesses by virtue of issuing orders to cease and desist. In our experience, businesses are aware of this gap in the law, and the worst actors take advantage of the interagency process and the OAG's discretion to take these matters. Although DLCP has the general power to suspend a license under DC Official Code 47-2844A, when in the mayor's judgment, such is deemed desirable in the interest of public decency or the protection of lives, limbs, health, comfort, and quiet of the citizens of the District of Columbia, or for any other reason the mayor may deem sufficient. DLCP must provide notice of its intent to suspend, which does not immediately go into effect. Pursuant to 17 DCMR 3804, if the department proposes to suspend a license, a written notice shall be provided to the applicant or licensee, which states the proposed action, the basis for the proposed action, and the date it is proposed to go into effect. If an appeal is taken, the suspension is not effective while the appeal is pending and only takes effect if and when the Office of the Administrative Hearings, OAH, adjudicates the appeal and rules in DLCP's favor. A stronger approach to enforcement would be to provide DLCP with the power to summarily suspend business licenses for imminent danger, violations of the CPPA, or ignoring a cease and desist order. This would allow the summary suspension to take effect immediately, as opposed to after a notice period or after an appeal is fully resolved through adjudication by OAH. This would also provide DLCP with more robust enforcement authority that would incentivize businesses to swiftly come into compliance and cooperate with DLCP. The structure for business license summary suspensions could easily follow the summary suspension process for non-health professional licenses, such as engineers, outlined in DC Official Code 47-2853.18, that OAH and DLCP are already familiar with. Under that structure, the aggrieved party has the right to request a hearing within 72 hours after service of notice of the summary suspension or restriction of license. If requested, OAH is required to hold a hearing within 72 hours of receipt of the request and shall issue a decision within 72 hours after the hearing. The ultimate goal would be to prevent recidivist behavior and protect consumers and the public in real time, thereby eliminating the pause in enforcement due to the need to refer to OAG for further enforcement in the DC Superior Court, which is pursued at OAG's discretion. Next, I would like to discuss the possibility of increasing fine amounts in the CPPA to better match the penalties for operating without a proper license. The only reference to fines in the CPPA is in DC Code 28-3905 I3A, which states that violators may be liable for a civil penalty not to exceed $1,000 for each failure to adhere to provision of an order issued by the Office of Adjudication, which no longer exists, or consent decree. Currently, operating without a license or without the proper business license carries a fine of $2,214 per violation. Across the board, updates to the CPPA fines could remedy this discrepancy in fine amounts. Alternative dispute resolution processes, like mediation, are almost always more effective and efficient than litigation, either at OAH or DC Superior Court. But right now, given backlogs in the courts, respondents are incentivized to simply wait out the issues and ignore agency requests to mediate. We believe that the CPPA could allow for DLCP to establish, by rulemaking, incentives for respondents to participate in mediation in good faith. And if they do, the fine amounts could be reduced or even forgiven if consumers are made whole in a timely manner. However, repeated offender would not be eligible for the incentive of reduced and or eliminated fines. Next, we would like to flag that the language in this bill sometimes mirrors but is not identical to federal consumer protection laws. Given the body of case laws interpreting analogous federal consumer protection laws, we feel it is important to be thoughtful about whether to purposely use language that is identical to analogous federal laws or use language that is distinctively different. The decision could impact the possibility and extent to which litigants may use federal case law as persuasive authority in DC courts. Finally, and from a much broader standpoint, there are fundamental problems with the CPPA that this bill does not address. The passage of the CPPA dates back to 1976. And while it has been modified over the years, many parts of it are out of date to the point where it specifies things that must be done in which are not in fact done because they have not been done that way in years, or can no longer be done in a manner specified. Overall, the CPPA needs a comprehensive review that eliminates all the old procedures that no longer followed. We would be happy to work with the council, OAG, sister agencies, and stakeholders, and share more extensive feedback on how to improve the CPPA if more time could be allotted to review this bill. Perhaps through the creation of a working group with all interested parties. Chairman Mendelson and members of the council, thank you for the opportunity to testify and provide feedback on Bill 24-658. With that, I am happy to answer any questions you may have.
Thank you, Ms. Conway.
Thank you.
So I have a few questions. Put me on a 10-minute clock. Thank you each of you for your testimony. Mr. Teitelbaum, one of the arguments that you make for the bill, or in support of the bill, updating clarifications, you cite to, for instance, the Facebook case, and that the argument there was no formal exchange of money or value. Why isn't case law sufficient here? Why do we need to update the statute if we've got case law on our side?
Well, Chairman Mendelson, this applies not only to that change, but a couple of the other clarifications, which is that while there is case law on our side, and while we've been successful in litigating these issues, we don't yet have binding Court of Appeal case law on any of these issues, because often these cases at the end of the day are involved informally, and there's no mechanism for it to go, the issue to be raised on appeal. And what that means is that there is still enough wiggle room such that creative and particularly well-resourced defendants like the big social media companies do everything they can to raise these arguments. And because there's no binding case law against it and no clear statutory prohibition, they can raise those arguments often just for the purposes of delaying our cases. Now, if this clarification were made, they wouldn't in good faith ethically be able to make the arguments at all. And thus these cases could proceed much more efficiently without us having to devote time and resources to having an unnecessary fight.
Okay, so the next social media company could say that they're different than Facebook, and it was a trial court decision, and therefore they could make similar arguments, and it would take time. But what about the next point, which was the unlawful transactions? I would think that's pretty clear. It's kind of hard to wiggle around that. Why isn't case law adequate there?
Chairman Mendelson, same exact issue. We do not have clear Court of Appeal precedent on the issue. And so even though we've had trial courts rule in our favor on this issue, even as recently as a month ago, we had in summary judgment briefing a defendant claim that because a particular statute that we say that they violated in the course of a consumer protection, in the course of a consumer transaction, was not specifically specified in the code, that the CPPA didn't cover it. And so while we point to our prior victories at the trial court level, they argue that the trial courts in those cases got it wrong. And they raise these, what we continue to think are meritless arguments, but they do create costs to litigate and often delay our matters.
All right, well then I'm sort of following along your testimony here. You talk about retaliatory conduct. Wouldn't our SLAPP law apply there?
I believe, I'm not an expert in our anti-SLAPP law. I believe that would provision would specifically apply only to actions that implicate constitutional rights. And I believe that is really only a defense to a lawsuit that is brought. So perhaps in the defamation lawsuit context, there could be a way to use the anti-SLAPP tool. But what is being proposed here would go beyond actual lawsuits brought by defendants against complaining consumers, but also other types of retaliation and intimidation, making threats, calling consumers and using harassing tactics to encourage them not to cooperate with us. Those are things we've seen in our cases. And as I mentioned, it does create a chilling effect that we want to prevent.
Well, that's helpful to understand. Maybe I didn't read or hear your testimony carefully enough. I thought it was about defamation lawsuits, and you're saying it could be other retaliatory actions besides threatening defamation lawsuits.
That's exactly right, Chairman. We cited that as an example because that happened in one of our cases, but it really is only one example of the type of retaliatory conduct that this provision would be intended to prohibit.
I'm making a note here. You also, in your testimony, Mr. Teitelbaum, and near the end, clarify that those who act on behalf of merchants can be held accountable for violating the CPPA, even if they don't have a direct contractual relationship with a consumer. Why isn't that opening the door to mischief on the part of the government? That's a horrible thing to say, but we do know that governments from time to time, or other governments, do sometimes misbehave. So why wouldn't that open the door to that?
I don't think it necessarily. I don't think it would, and that this would encompass those who are agents of a merchant under the statute. And the current definition of merchant is limited and would not necessarily apply to most government contexts. And I can't think of a scenario in which the government would be considered an agent of a merchant. But if that's a concern, I'm also—
No, I didn't mean it that way. I meant that, the power of the state is pretty powerful. And so this is to go after actors who are not directly contractually related to the consumer.
That's right. And now I understand the concern. The intent of what we think is really a clarification, because we've successfully argued that a contractual relationship isn't required. The intent is to make sure that a company, a bad business, can't elude liability by structuring the transaction in a way such that they don't have a contractual relationship with the consumer, but they're still doing bad things that are having negative impacts on consumers and that would otherwise violate the law. Or, for example, an example would be a property management company where they're not necessarily the landlord, but to the extent they're engaging in unlawful, deceptive business practices, lying to tenants, not refunding appropriate fees, et cetera, to make sure that if they're the bad actor behind the conduct, they don't get immunized from liability just because they're not on the other side of a particular, directly on the other side of a particular transaction.
So there has to be a clear agent relationship, but not necessarily a contractual relationship. An agent relationship to the merchant, if you will, but not necessarily a contractual relationship with the consumer.
That's exactly right. And I think that's what the proposed amendment would clearly reflect in the language. And we're happy to provide the council with a proposed law language to that effect.
You'll have to. But so now let me ask this question. This bill was introduced on February 9th, 2022. And I have the distinct impression that the Attorney General's office, which likes the bill, has not sat down with either DCRA or the Department of Licensing and Consumer Protection to discuss the bill and ensure that everybody's on the same page. Why not?
So I'm happy to address that. And as I mentioned in my testimony, and to take a big step back, I wholly agree that DLCP is a real important partner here. We've worked really well together collaboratively in the past. As I mentioned, referring matters to one another, working with one another. I think the reason that we were so directly involved in the bill at the outset was because many of these, if not most of the amendments, largely impact areas that really are unique to OAG's enforcement authority. So OAG is tasked as the only agency that can litigate these matters in court, and is the only agency that can seek certain remedies, penalties, et cetera, and that can conduct certain pre-suit investigations. Many of these apply exclusively in that context. And the other provisions that clarify some of the broader CPPA provisions really wouldn't impact in any negative way DLCP's authority, wouldn't limit their authority in any way, and in fact only broaden the types of misconduct that both of our agencies can go after. That being said, given that context, we hadn't anticipated concerns and hadn't heard any during the 9 months that the bill was pending. I do hear the concerns now. I can say the specific provisions that my colleague, Ms. Quan Hui, has mentioned are eminently fixable, and I'm confident that we can reach resolution on, both in terms of the concerns that she's raised, as the small handful of provisions where she's raised substantive concerns, and as to the additional provisions she suggested in terms of DLCP's authority. Happy to take a closer look at those, but I will say they all strike me also as eminently reasonable and ones that we can largely incorporate into this bill and support.
So you're more than willing to work with DLCP and Ms. Conway to resolve a lot of this or work all this out?
I think 100% of it, Chairman, can be resolved. I communicated, I had a discussion with Ms. Quan Hui yesterday and communicated that I thought these were all fixable. I think we can do that quickly. I would say the vast majority of these provisions, Ms. Quan Hui has not raised specific objections to, and in fact, no stakeholders have. They're important protections that are affecting real consumers now, real issues that we're aware of. And I don't think those should be held up while we resolve these concerns, but I'm confident we can do that very quickly.
I'm going to have some more questions, but let me turn to my colleague, Councilmember Pinto.
Great, thank you so much. And thank you to you both for your testimony and your work to protect consumers. Ms. Quanway, I want to start with you. In instances where you find a business is out of compliance with licensing requirements, how much time do you generally provide them to get into compliance before seeking to close their business?
Yes, good afternoon, Councilmember Pinto. Thank you for your question here. So in terms of the businesses, we first receive a complaint, or it could be a proactive action knowing that they are no longer having an active license. So we have a 30 days investigation timeline, but starting at the beginning, we have about like 3 days to look at the initial complaint, and also looking at the business licensing requirements and the current status that we have. And then if they are found not to have been in compliance, they immediately is being notified, and that they need to work with our licensing department to make sure they come into compliance. However, if they are not in compliance or not being cooperative, we will go ahead and just issue a NOI.
Okay, thank you.
You're very welcome.
And I understand that it sounds like DLCP is opposed to providing OAG with rulemaking authority. What would you propose alternatively to ensure that OAG has the rules in place necessary to be effective litigators when it comes to consumer protection?
That is correct. We opposed OAG to have a rulemaking authority for the CPPA. We strongly believe that the DLCP should be the principal consumer protection agency, and the rulemaking authority should reside at DLCP. And like I mentioned in my testimony, we're very interested in doing a working group with OAG, other sister agencies, and also communities and advocacy group or consumer protection groups, so we can get all the different perspectives, so we can able to holistically look at it from a very comprehensive view to really bring the CPPA into the modern world of like what we are doing with the businesses, because it is a very important for us to protect our consumers and the businesses as well, because it really play a critical and vital role to in economic recovery for the District of Columbia after the pandemic. If people are being cheated or deceptive, they're not going to be coming to the District of Columbia to be a resident or consume any services or goods in the District of Columbia.
Mhm. Well, thank you so much, Director. And I think it's clear consumers need to be protected, and I'm grateful to both of your offices for doing this work. Director Tadelbaum, alternatively, from your perspective, can you elaborate on why you feel it's so important for DLCP to not be defined as the principal consumer protection agency within the CPPA, and how you think that the role of your two agencies could be better defined in the law?
Sure. Thank you, Councilmember Patel. To be clear, the provision would repeal, the proposal would repeal that provision that indicates that DLCP is the primary consumer protection agency. My understanding is that the intent behind that was not at all to suggest that DLCP, along with OAG, are both important consumer protection agencies, but rather that that is an outdated provision that actually has been in place since the 70s, before OAG even had gotten enforcement authority at all. And so really it was meant to be, I think, a minor change just to reflect the current reality that there is now more than one agency engaging in this important consumer protection work. I would also note there have been some real world impacts to that. We've had defendants point to provisions like that in our enforcement actions to suggest that we shouldn't have, that we don't have authority to hold them accountable. Again, sort of a common theme, we've won those, but they've been hard fought. But I don't want to be, this is not a provision, I wouldn't want this provision to hold up the other important substantive aspects of the bill. So we're very open to other ways to address this rather than a straight repeal, having it having the language clarified to reflect both of our agencies' important roles in this area. And the precise language is not particularly critical to our office.
Okay, thank you so much. And thank you for re-highlighting that example of the practical effect, because you're certainly correct that the intention of repealing that language was just to make clear that both agencies can move forward, and that argument would not hold any water, even though you won it last time. We want to be clear in the law, but thank you for that clarification. Do you have any issue, Director Tadelbaum, with us extending the anti-retaliation provision to complaints that are brought by DLCP?
None at all. No, and I mentioned this in my testimony. I think it's a great idea, and that there should be no reason that those who complain to DLCP would not have equal protections that those who complain to our office.
Okay, thank you. When a business fails to comply with a cease and desist order that's issued by DLCP, in what instances does OAG decide not to move forward with injunctive relief after a DLCP referral? And in how do you have on hand how many instances OAG has decided not to move forward in those circumstances?
Sure, Councilmember, that's a great question, and one that also, as I heard the testimony, rose in my mind, because to my knowledge, at least over the past year, since I've been in this role, we haven't once been referred any complaint in this circumstance, and certainly haven't had a circumstance where we have declined to take action when referred a cease and desist like complaint to our office. Theoretically, were we to receive one of these, we would evaluate them as we would in any circumstance and work collaboratively with the agency to understand why they engaged in the action. And I would hope in the vast majority of cases, I would expect that we would share the view that action needs to be taken. That being said, again, we'll need a bit of time to review the specific proposals that Ms. Kwan-Hui mentioned. The suggestion that the agency should, in the interim, have some ability to suspend licenses doesn't strike me as raising any concern, and seems to me at first blush to be a good idea in the hopefully rare circumstances where there is a gap. And while we need to take a closer look, I think is likely something our office would support.
Okay, thank you so much. And because we have a little more time left, Director Kwan-Hui, back to you in terms of the rulemaking question. So I hear you that you don't think that OAG should have this rulemaking authority and that your agency should be the ones with this authority. But if we were to agree with you and adopt that route path, how would you propose that we ensure that OAG has the tools they need to be effective litigators when cases are brought?
Thank you, Council Member Pinto, for allowing me to elaborate on this thing here. So like I mentioned with the working group, I do think that besides OAG, other stakeholders also are important to be brought on to this working group so that we have all different aspects of viewpoints on this here. And during the working group, we can do like a phase host approach, and we'll make sure that OAG's their needs are going to be met during this working group, so we can move forward to some of the agreements that we have in place in the spring session here. And then it's so important that the CPPA needs to be updated, as you mentioned at the opening statement. So I think that we have a common goal here. We have a common interest. And like the conversation that I have with Ms. Tettelbaum yesterday is that, we're willing to work together to make this happening, to make sure that we can have updated CPPA to serve the consumers better. So I think that we have the common goal. I think, and we had a really great conversation yesterday, and we have a monthly meeting before my predecessors at the DCRA, but it ended in August because the agency had to focus on the agency split. However, I do wanted to reconvene that so we can able to discuss about this bill and also any other changes that we have. And it's so important that we need to include the consumer advocacy groups, and especially the people in the immigrant background who are the most vulnerable in terms of being misled or get into a situation that, they're not getting their goods and services. So really need to really bring in a collaborative approach and not a piecemeal approach to this thing. So we do oppose the current form of the bill, but we're willing to work with OAG and other stakeholders so that we can have a holistic, comprehensive approach.
Okay, brings me to the end of the round. Thank you both very much. And I, generally am a supporter of working groups and trying to resolve some of these issues. It seems that some of the provisions that you take issue with, OAG is open to working on some of them. I think the broader concern of being the primary or clarified in law agency that is responsible for these cases, I don't think is aligned with the kind of purpose of this bill and of the clarifications that we think OAG needs in order to most effectively bring these cases. But look forward to continue to work with both of your offices and hopefully move forward on some compromise.
Thank you so much, Council Member Pinto. And if I may just as last thought on this one here is the dual making authority, does not work because of the conflict of consistency that might have in the future. So that's why we really think that the working group approach is the best approach. So thank you very much.
Thank you. Thanks, Chairman.
Yeah, and I think I'm going to depart from usual order and ask Councilmember Pinto a question. I wasn't quite sure what you just said with regard to the primary agency.
So I was referring to some of the changes that DLCP has asked for about retaliation, or let me look at some of the other examples, making sure that the bill is going to be carried out as intended. OAG seems to be open-minded to some of that, and I think some of that may be able to be resolved without a full working group. In terms of the comments of wanting to take away the repeal, because right now this bill repeals the language that sets up DLCP as the primary agency that's responsible for consumer protection and rulemaking. That piece we were hopeful for would make clear that OAG was also responsible for consumer protection cases, as Director Taitelbaum was speaking about some examples of litigation where other opposing parties have brought that up as a concern. And so I was citing that as an example of that might not be able to be remedied in terms of a working group, because that was a piece of the bill that was kind of central to why we introduced it.
Thank you. But what goes through my mind, and I think I'm going to sort of turn to Mr. Teitelbaum now, is the issue is not so much to take away from DLCP that it's the primary agency, but rather to clarify that the Attorney General has standing, if that's the issue, standing to bring cases that haven't gone through the DLCP process. Would that be a correct way of characterizing it, Mr. Teitelbaum?
I think that's right, Chairman, although the arguments that defendants have raised in this context are not always specifically standing. They talk about statutory authority and they find differing ways to be creative with this argument. Really, and I want to emphasize that this is a minor point that I really am hopeful we can reach some sort of compromise on. To where you started, it is exactly right that we don't view this proposed change as intending to take away either authority of DLCP, nor to reflect that they should are anything but an equal partner in enforcing consumer protection laws, but really to reflect the accuracy of what's currently in place, and that there are two agencies, and to take away any creative arguments defendants try to raise with the current statute that does declare only DLCP as the enforcer, as the primary, rather the principal.
Yes. So if we added language to the law that said DLCP is the primary agency, and if the Attorney General brings a case, it has the authority to do so.
I think something along those lines would be perfectly acceptable to our office, yes.
And then whoever it is that says you don't have the statutory authority or the standing or whatever reason you can't do it, you can point to language that explicitly says you can do it.
Yeah, I think that would fully address the concern, Chairman.
But then that leads me to a line of questions. It might only be one question. And that is, I think the way the law was written, it was sort of the standard scheme in government, which is that we have an administrative agency, in this case DLCP, which does on behalf of the government consumer protection. And when it has problems, as in somebody who's not being responsive, it goes to our litigation agency, the Attorney General, and the Attorney General then pursues it in court. I think that's the general scheme. And it sounds to me like what the Attorney General has been doing in the last few years, and I don't mean this as a criticism, is it has been initiating on its own cases on behalf of consumers, such as with regard to Facebook or the opioid epidemic. I think that's opioid is where you joined with other states. And that's kind of outside the traditional scheme. And I don't want to take that away, because I think it's good that you've done that. But under what authority have you done that?
So, Council Member, Chairman, I actually think that the typical scheme, if you look at other attorneys general offices throughout the country, is that attorneys general always have the discretion to bring cases through a variety of pipelines. And as I see it, the more pipelines we have of learning about issues that can be affecting consumers, the better. Here, one of those key pipelines is DLCP. And we get, as I mentioned, we refer matters to them, they refer matters to us. I think the CPPA has always been set up not to suggest that the sole pipeline is through DLCP, but to suggest that there is a separate administrative process for addressing matters, for example, that aren't appropriate for litigation, either because of the scope of the harm or the fact that they can be resolved through other administrative or informal mechanisms. For example, unlicensed businesses or more discrete consumer complaints. Those are exactly the types of things that we refer to DLCP in the first instance. And I think that's how that scheme has worked very well. And to your specific question, under what authority do we do so? It's that the statute grants us authority to bring investigations and cases under the CPPA, and in no way limits that authority to only cases or investigations that come from DLCP. So the authority comes from the fact that there is no limitation in terms of the sources of the cases that we're able to bring.
Well, you also have authority under your enabling statute to advocate on behalf of the public interest.
That's exactly right. That is another source of authority, and that source of authority is also not limited to bringing litigation and using other consumer education means, et cetera, toward that end. And I know that's something that DLCP also does, and something I look forward to collaborating with the agency on.
All right, I think I just have a couple more questions. I think I'll leave it with this. There's some work to be done on this. It's pretty clear there's some work to be done. At a minimum, OAG and DLCP need to sit down together and work things out. To be clear, my own view is I don't have a problem with the Attorney General asserting on behalf of consumers, but I'm not interested in taking away DLCP's responsibility in this area. And my guess is that there's enough to be done in the realm of consumer protection, and where the Attorney General is more likely to be involved is where it's litigation as opposed to on an administrative level. So I think there's a lot that can be worked out here, and that's what I want to see. I want to say, I take a dim view of working groups, because working groups, I'm looking at you, Director Conway, working groups, I think of months, if not in terms of half years or full years. I'm not sure I have that level of patience here, because I don't think this is that complicated. The reality is that it would be hard for us to work everything out, we here at the council, to work everything out this calendar year. We have 3 legislative meetings left. But I don't know why the 2 agencies can't sit down over the next couple of months, November, December, work these things out. The Legal Aid Society is going to give us written comments, so clearly they have some interest in this. But you can just have a conversation with them. And I think there are a couple other groups that have been active in this space, and you could have a conversation with them and just put everything on the table and work it out to come up with a better bill. And then that bill could be introduced in January. Let me just kind of run through this. So if the bill's introduced in January, and the agencies are still under the committee of the whole jurisdiction, we could have a hearing at the end of January, beginning of February. We need 3 weeks for notice for a hearing. And then we could mark up the legislation before the budget, which is the end of March. Otherwise, it's next summer or even next fall. And I think all that's doable, because I don't get the sense that any of this is unresolvable. in terms of strengthening DLCP, strengthening OAG, and updating the law.
Chairman, thank you so much. I absolutely agree with you that this is what we're hoping for, a chance for DLCP as a new agency to able to work with OAG and other stakeholders to come up with ways that we can improve the CPPA. And I do agree with you in terms of like the concern of the of working group. It could be months and so forth, but we can definitely take on a phase approach. And for the ones that who are the most pressing matters, the ones that are like, most urgent, we can able to get together and be able to have something mark up for the spring session that you have mentioned. Although like, we might not have a comprehensive overhaul by that time, but we should at least have like, similar interests and things that we have discussed during today's bill. But absolutely that, the LCP needs to remain as the principal agency. And that we should have the sole authority for the rulemaking, so that this way we don't have any consistencies and confuse any of the public and the businesses. And Legal Aid Society is also one of the organizations that is on my list to be part of this working group, besides other community advocacy groups and sister agencies and OAG.
Mr. Tettelbaum?
Yeah, thank you, Chairman. I think ultimately we're happy to work on whatever schedule council suggests. What I would say is I do think, what I heard in Ms. Kwanhui's testimony were 3 specific concerns with the current bill, all of which I think truly are not critical aspects of the bill and we can resolve in a matter of days. And she's also suggested some additional tools for DLCP to have that I also think in a matter of days we could come to agreement on. And so I wouldn't want to foreclose the possibility that we can actually reach full agreement on a bill, given that there are a number of other provisions here that we've heard no objections to that I do think would be very critical to district consumers to be in place sooner rather than later. I wouldn't want to foreclose the possibility that we can have a bill passed this session.
Well, I'd say go for it, but there's the work at our end as well. So, but I think, do your best to come up with an agreement. And if there is an issue, I'll just say rulemaking that you can't reach agreement on, put it aside and argue your case before the council.
And Chairman, on that point, if the rulemaking authority issue is what would hold up the rest of the bill, we're willing to not focus on it for this bill. That's how strongly we feel about the other protections being put in place.
And Mr. Chairman, if I may say a few words.
Yes.
Okay. So I truly do not think that we should rush this. And it's not just about the rulemaking, it's that we have to be very thoughtful. As earlier conversations that you were asking about specific, choosing a specific language, it has some indication about, how the court cases is going to be deciding in the future. So we need to be very thoughtful about whether or not we wanted to align specific jurisdictions or federal like consumer protection. So having a working group and working closely with OAG, I think that we should come into a compromise and agreement to do that. So this way we're not rushing into things here. So I don't think that this could be resolved in a matter of days. I think that the original proposed timeline that you've mentioned, it sounds much more doable to us.
As I want to say, talk amongst yourselves. I've been through this a few times and in other contexts, and it's always better when folks work things out. You make a good point about how to interpret the language, but since you all, meaning DLCP, have been in the thick of this for years, and since OAG's been in the thick of this litigating for years, you ought to have some sense already of where there could be pitfalls with particular language choices. I don't know this area that well, but do we want to be analogous to the federal statute? Do we want to be analogous to the California statute? Or we can just be clear in our intent through your statements and our committee report. There's a lot of options and a lot of flexibility here, but if things are not worked out fairly soon, and I didn't say days, but I also didn't say in the spring session, there's always the chance that a council member could introduce a bill and that we move forward. And so just work together.
Will do.
I
Mr.
think that'll be a beautiful sight, and it'll be the first thing for the holidays. We're not even at the holidays yet.
Certainly.
I'm all for that, Chairman. Thank you.
As I said, we don't have any other witnesses, but we know of at least one other group that's going to be submitting comments, and you can reach out to us to get a copy of the comments. Thank you both. I'm going to close up this hearing, take a few minutes, and then I have another hearing that I will start. As I indicated at the beginning, the record in this matter will close at 5 p.m. on Thursday, November 17th. That's simply for the purpose of what we have to file as the record. This is a legislative branch, and we consider stuff right up to the end. So thank you again for your testimony. The time is 12:47 in the afternoon, and this hearing is adjourned.
Thank you.
Thank you.